From the WATE.com Digital Center, answering your legal questions, this is Ask Isaacs. Now, here's Lori Tucker and attorney Greg Isaacs.
Hi there, everyone. Thank you so much for joining us today. I'm Lori Tucker, along with our legal analyst, Greg Isaacs. And this is a topic, Greg, free speech, that we've talked about before. What constitutes free speech? But given a recent story that really has been making headlines, people still talking about it on social media, especially, is the Sevierville police officer's resignation after he made what many believe to be an inflammatory comment on another TV station's social media page. And this was regarding the recent assault on U.S. Representative Ilhan Omar. So let's fast forward. This police officer turned in his resignation after the firestorm over this comment. So a lot of people on social media, Greg, are saying, hey, what did he say that was so wrong? Why aren't his free speech rights protected? So let's talk about the fact that they aren't always protected.
You know, they're not always protected. And you know, we see it time after time when you have a high-profile case. And, you know, the case involving Representative Omar's is a good example. People feel compelled. When you talk about speech, you know, some of the cases talk about the town hall, how our country was predicated and founded on our founding fathers and dissent and the right to express those opinions. But fast forward, the town hall is now Facebook. It's now Instagram. And, you know, you have a lot of people coming forward to make comments in the spur of the moment, some on a whim. The thing that really always amazes me is people think when you get keyboard strong, you have this cloak of invisibility. But, you know, the First Amendment is not an end-all or beginning in terms of a protective bubble against claims.
And let's explain that. So bottom line, and we're talking about now former Lieutenant T.C. Faulconer of the Sevierville Police Department. Is his speech protected?
Well, let's look at whether it is or whether it's not. First, you know, when you talk about First Amendment protections, you have to look at whether you are a governmental employee or whether you are in the private sector. Remember, the constitutional protections, you know, typically attach when the government is involved. So, you know, let's look at it. This Sevier County officer,
or
obviously,
Sevierville,
was employed by government in law enforcement. So then you have to analyze whether the comments were made in his personal versus official capacity.
We have the video of what happened, of when that assault took place, just to make sure you know exactly what we're talking about. So there it is. And then the officer posts something that I don't feel comfortable saying because we were not able to independently confirm it. It looked like the comment was hidden not long after it was posted, but it has been widely shared. And it has been interpreted as invoking a component offensive to Omar's Muslim faith, given the religion's prohibition on pork, and that's as far as I can go.
Yeah, and there's no sense in rehashing a comment that's full
Bottom
of
line
acrimony and vitriol. And I think that video is worth 1,000 acrimonious, vitriolic comments on the Facebook. But you know, it's interesting. So let's look at what happened and how it happened. So in response to this, now it's one of the tests that the Supreme Court looks at if a employee is making a comment, a governmental employee, as a private individual in his personal capacity. Is this a matter of public interest? Public official, yes. So we check that box. Obviously, Omar's a very lightning rod-esque public official. So yes, did this individual speak on behalf of this Sevier County law enforcement? No. He made a comment on the Facebook that we're not going to delve into, but it had clearly some racial overtones, some very inflammatory overtones. So can there be First Amendment protections? And
Now, even if he's speaking as a private citizen, he still holds a position of power within the community.
right.
So where do you define
So
those
here's
two?
what the Supreme Court has said time after time, and the Pickering test, that's a 1968 Supreme Court opinion.
Pickering
is
versus Board of
the
Education.
Board of Education. And what you're supposed to do is here's the analysis. Was this a matter of public concern, this being the act that was the subject of the comments? Yes, it was a matter of public concern because this is a high-profile elected official. Now, here's where things are never, there's always 27 shades of gray between black and white, the First Amendment. Here's the test: whether the government employers, law enforcement, interest in workplace efficiency and avoiding disruption outweighed the employee's right to free speech.
So what did his bosses do? You think they went down and looked at all those comments on social media thinking, all right, this is a community officer. How is this going to impede his
Well,
job?
and further, the Supreme Court talks about whether the statement material disrupts the entity's operations. So basically what happened is after the employer became aware of the comment, they placed Faulkner on administrative leave. Then he in turn resigned. So, when you look at it through the lens of, maybe the first step, he was commenting in his personal capacity on a matter of public concern. You're fine. You can wrap yourself in the flag and the First Amendment, beat that fife and that drum. But then here's where it gets dicey. For the employer, did that comment outweigh his First Amendment speech interest? Did it outweigh workplace efficiency or materially disrupt operations? And here's the rationale. If you're an officer and you're charged with enforcing the laws, law enforcement, you are to be impartial when you discharge those duties. And if you're seen publicly making comments that can be construed as being racially motivated, ethnically motivated, discriminatory for a class of people, then in theory what you could do is jeopardize potential arrest. You could jeopardize interaction with certain individuals that would come under those comments. So the last thing you want if you're law enforcement is to have somebody that's got a predisposition against a particular group,
If
et
there's
cetera.
a bias or whatever.
A bias.
So that goes back to my original question. Is someone like a law enforcement officer on social media ever considered a private citizen just by virtue of what they do? You've got to be so careful.
Well, it is, and here's the test. This person wasn't speaking at a press conference on behalf of the Sevier County Police Department, et cetera.
He was just speaking to the world.
Well, he was talking on Facebook. But remember, when you become keyboard strong and you want to express, and everyone, Lori, is entitled to their opinions.
Certainly.
That's what this country was based on. People have fought and died for. But when you venture into the World Wide Web, those comments, people are watching, people are listening, and just remember, the First Amendment doesn't cloak you in invincibility and invisibility. You make a comment, and wow. So you're the employer, and you've got to balance. Is this disruptive for the workplace? Is this going to jeopardize arrest, efficiency? And, you have to make that balancing test. But, in this case, we'll never know. Because as soon as the officer was placed on admin leave, officer was smart, hands in his resignation. So
We don't know what went on behind closed doors.
we have
What
no
the
we have no
conversations
idea.
were after he was
Yeah,
placed on
so and you came
administrative
and it would be inappropriate to draw any inferences,
Of course.
but just remember, if you're a private employer, there is less First Amendment protections for your employees. Typically, well, I know in Tennessee and most states, you're an employee at will unless you have a contract for employment, or you violate one of the civil rights or your state civil right equivalent protections. You can't discriminate against someone based on their age, race, sex, ethnicity. But you don't like the comment. If you're an employee at will, you think it reflects badly, and you're in the private sector, you have that right. Now,
we do have a statement, if I may share it really quickly, from Sevierville Police Chief Joseph Manning, who said, comments of this nature are inconsistent with the standards and expectations of the Sevierville Police Department. So that was the statement we received, and it goes on to say, particularly when directed toward an elected public official.
Well, the Chiefs kind of got it backwards, because when it's elected, when it's directed at a matter of public concern or public official, that creates, and you're doing it in your private capacity, a First Amendment protection, unless you apply the balancing test, and it's disruptive to workplace efficiency, and it's disruptive. So, Faulkner was halfway home, being in his private capacity on the Facebook, talking about a matter of public concern. Until you reach that level, it's not disruptive until it is. But, we're seeing this now over and over and over, and algorithms pick certain things up, and you can see something just, posts just go, wild, create a tsunami of attention when, you're sitting there late at night, or you're whatever, and you just want to give somebody, your 2 cents worth, and you hit send,
and you want to
or
beat
hit
your
post.
head against the wall.
Yeah, and you can't delete it. It's like a mugshot.
Yeah.
Sometimes people call and go, "How do we make this thing disappear?" Well, you quit looking at it. How do you keep from getting terminated for making comments in your private capacity? Don't put them on the internet.
Don't put them on the internet.
If this would have been done at a coffee house, a tavern, or whatever, probably not a big issue, because when it becomes that public, then the employer's interests become
and it's
balanced.
right there in black and white.
Yeah,
There's a relevant case I'd like to talk to you about. And this is the teacher terminated for social media post. Last year, Supreme Court declined to hear the case. This involved a Massachusetts public school teacher terminated for offensive social media post, affirming lower court's application of the Pickering-Connick balance that we talked about, and indicating that public employee social media activity can be regulated by employers when justified.
Absolutely. And, we're seeing this time and time again, in a good example or a bad example, however you look at it, is Charlie Kirk. Because how many people did something analogous to what this Sevier County law enforcement officer did?
Well, we had the local case at UT.
A local case, and then action was swift, fast, and furious by employers and whatever. And then what people wind up doing is debating the Pickering test. So just remember, when you feel compelled, you're not in the town square like it was when the First Amendment was there. When you're on the World Wide Web, they don't call it the World Wide Web for nothing. And algorithms and other things, it's really remarkable how things can really spread like wildfire.
Does this officer have any grounds to
I
appeal?
don't want to give someone legal advice. He didn't appeal. He resigned. He was on
That's
admin
true.
leave. So
That's
let's
true.
just be very clear in this.
Yeah.
He was not overtly terminated. He was not,
As far as we know,
disciplined in any way other than being on admin leave, which typically signals there's an investigation going. The comments from the police chief tend to very clearly delineate that this when you apply the balancing test, this public comment, the comment about a public official as a private individual, was disruptive and not consistent with the culture of that law enforcement agency. But
is that enough to provide grounds? Did they have grounds to terminate him, or we don't know what went on behind closed doors, so we don't know.
So he wasn't terminated. So
No.
that's not the issue. The issue is you just need to know when you're on Instagram, when you're on X, Twitter, when you're on Facebook, you do not have an absolute First Amendment right. if you're a government employee, you have more protection than a private individual. But it's really interesting how, and this comment, which was ethnically and potentially religiously, it was a slur, goes to show you, and when you talk about hate speech and things like that, employers do not want someone that is violating their core beliefs, disrupting their ability to efficiently control the workplace.
Yeah,
So
just do business as usual. You don't need any toxicity.
yeah, so it's just amazing. The First Amendment does not give you a cloak of invincibility. And just remember, when you make those comments that are vitriolic or sensational, and you think maybe the 27 Shades of Gray.
Maybe everybody
what would
agrees with me.
my employer think?
Yeah.
Well, you need to really take that to heart, because like the case that Lori you mentioned, the Supreme Court just recently failed to hear a case involving a Massachusetts public school teacher for having offensive social media posts. So really remarkable how the First Amendment we see is not a complete protection when you want to engage in public comments.
And that's one of the main reasons we're doing this subject today, that we're tackling this, because as I mentioned on social media, there was a pretty large outcry in support of this officer, saying, what about his First Amendment rights? So people were
again,
saying, wait a minute,
I want to be
you got
clear.
to understand what it means.
We're not saying that the comment was appropriate.
No.
Not appropriate.
We're looking at the law, the framework of the law.
And here's the deal. And when you're doing the balancing test, you've got to put yourself in the shoes of the governmental agency or the governmental employer. And I think if you look at Chief Manning's comments, it clearly just said, if we can go back to the beginning, can we do that, Madam Producer?
Here we go.
And here's how you sum it up. Comments of this nature are inconsistent with the standards and expectations of the Sevierville Police Department. It doesn't mean that they're wrong. It doesn't mean that they're moral. It doesn't mean that they're amoral. It doesn't mean that it's something that could have been, what it should have been, not said. It just says, for us, this particular law enforcement agency, it is inconsistent with standards and expectations. And that's it. That's the end of the day. So you can talk about First Amendment till you turn blue. You can wave the flag, but when you make those comments, just know the arbiter is going to be your employer, and whether that comment is consistent with their core values and whether it is materially disruptive. So before you hit send, think who might be looking over your shoulder. And just because you get a lot of likes on the X or the Twitter, the only like or dislike that matters is that's the person that signs the paycheck. So, be careful. The First Amendment is sometimes it's a trap for the unwary. And when you mix the First Amendment and social media, often it's a very toxic cocktail that before you know it, it's kind of like throwing a match in the middle of summer when it's dry. You've
there are
started
definite
a fire.
limits. Great way to put it. Definite limits on social media posts when it comes to the First Amendment and whatever your job is. So we'll leave it at that for now. Let's talk more at 5:30, shall we?
Let's do.
All right. Thanks for being with us.